Article 34.2, subparagraph A, subparagraph 4 of the model law sets out another ground to set aside, which is the composition of the tribunal or arbitral procedures were not in accordance with the arbitration agreement. These are procedural grounds, which are deficiencies in which a tribunal was appointed or the arbitration procedure was conducted and results in the lack of due process. Certain minimum procedural standards must be observed so that arbitrations can be conducted fairly and properly. One must ensure the proper constitution of the tribunal. Also, that the arbitral procedure is in accordance with the parties' agreement. One must ensure that parties are treated with equality and are given fair hearing, with full and a proper opportunity to present its case. But not all violations in the arbitration agreement should call for the setting aside of an award. One needs to inquire whether such violation is material and is important on the procedural requirements, the departure from which would result in an extreme and prejudicial situation for the party. An example is when in an arbitration of a dispute of a three-party consortium agreement made by a three-man tribunal, where claimant was able to appoint one arbitrator, but the two other respondents with distinct and contrasting interests were compelled to appoint only one arbitrator. According to the Supreme Court of France, parties' agreement was against public policy because it violated the principle of equality of the parties, which could not be waived. Please note that the second part of the Article 34.2, subparagraph A, subparagraph 4 provides that where the agreement conflicts with the provisions of law from which parties cannot derogate, the non-compliance or deviation from the agreement of the parties shall not be a ground to set aside the award. Of course, differences on how to implement these due process principles exist from state to state. Different courts, different states approach this issue from their own particular national standpoint.